Most people believe a traffic stop begins when the police officer walks up to the window and asks a question. It doesn't. By the time the officer reaches your door, the most important part of the stop is already happening, and the truth is, something almost nobody realizes until they're sitting in a courtroom months later, watching their own body camera footage play on a screen while a prosecutor pauses the video and says, "Right there, that's where the driver changed the entire case." The first 60 seconds decide everything, not the search, not the arrest, not the ticket. The first 60 seconds. I've reviewed hundreds of body camera videos, dash camera recordings, police reports, and suppression hearings, and if you sit in a courtroom long enough, you start noticing something unsettling. Cases that look complicated on paper often hinge on something very small that happened almost immediately. A sentence, a tone, a nervous laugh, a driver trying to be cooperative, a person talking when silence would have protected them. And when judges watch those videos back, they aren't focusing on what most people think they are. They aren't looking at whether the officer sounded polite. They aren't watching for fairness. They're watching for something much more specific. They're watching what you did in the first 60 seconds. Because those 60 seconds set the psychological tone, the legal foundation, and the investigative direction for everything that follows. Here's where this gets complicated. Most drivers approach a traffic stop with the same instinct. Be nice, answer questions, don't make things awkward, maybe even chat a little. That instinct comes from a very human place. Nobody wants tension with an armed authority figure standing beside their car in the dark. But the system doesn't run on instincts. The system runs on statements, observations, and reasonable suspicion. And the moment the officer approaches your vehicle, the stop begins to transform into something else entirely. What starts as a simple traffic stop can slowly evolve into a DUI investigation, a drug investigation, or a fishing expedition for anything that might justify extending the stop. The first 60 seconds decide everything, not because of some secret rule in the law, but because of how human behavior works under pressure. Imagine the scene. You're driving at night. You see red and blue lights in the mirror. Your heart rate spikes instantly. Your brain starts racing through possibilities. Did I speed? Did I miss a sign? Did my tail light burn out? Adrenaline doesn't make people calm and precise. It makes them talk. And talking is where the system begins building a case. An officer walks up to the window and asks what sounds like a harmless question. "Do you know why I pulled you over?" That question is not random. It's designed to do something very specific. Get you talking before you've had time to think. Drivers often respond instinctively. "Was I speeding? I might have rolled that stop sign. I'm sorry, I'm just tired." Those statements feel harmless. They feel polite. But in the legal world, they become something else entirely. Admissions. And once an admission is on the record, it changes the legal posture of the entire encounter. Now, this is the part most people misunderstand. Police officers are trained observers of behavior. Not just criminal behavior, but nervous behavior, hesitation, tone changes, eye movement, hand movement, breathing patterns. During suppression hearings, officers will testify about things that most drivers never even realized they did. The driver appeared unusually nervous. The driver avoided eye contact. The driver's hands were shaking. And here's the uncomfortable truth. Many of those observations are completely subjective. But courts allow officers to rely on them. Which means the way you behave in the first 60 seconds doesn't just affect the conversation, it becomes evidence. Let me be honest with you. Officers also understand psychology extremely well, especially in those first moments. They know that most drivers want to appear cooperative. They know people will often volunteer information without being asked. They know silence makes people uncomfortable, so they allow silence to hang in the air. And then they ask another question. "Where are you coming from tonight?" Again, it sounds harmless. But that question is rarely about location. It's about creating a timeline, a narrative, a set of statements that can later be compared, tested, or challenged. And the moment the driver begins explaining their evening, the stop quietly transforms into an interview. This is the trap. Because once someone starts explaining themselves, they tend to keep explaining. They add details. They try to sound believable. They try to sound calm. But adrenaline makes memory messy. People misspeak. They contradict themselves. They say something slightly different 2 minutes later. And now the officer has something very useful. Inconsistency. Inconsistency is one of the easiest ways to justify extending a stop. If the driver said they were coming from work but later mentioned dinner with friends, that small difference can suddenly become suspicious behavior, which leads to more questions, which leads to more time, which leads to requests. Mind if I take a quick look in the car? The first 60 seconds decide everything, because by that point the officer has already decided something internally. They've made a preliminary judgment about whether this will remain a simple citation or evolve into something more investigative, and the driver usually doesn't even realize the moment that decision happens. Now there's a phrase that can change the entire direction of that encounter, a phrase that lawyers quietly wish more people understood before they ever see the inside of a courtroom. The phrase is simple. I'm choosing to remain silent, and I would like a lawyer if you're investigating a crime. That sentence does something powerful. It establishes a boundary. Legally, the Fifth Amendment protects a person from being compelled to provide testimonial evidence against themselves. But here's the critical nuance, that protection isn't automatic in conversation. It has to be invoked clearly. Silence alone can be ambiguous. Courts have ruled that unless a person clearly invokes their right to remain silent, officers can continue asking questions and using the responses. So the phrase matters. I'm choosing to remain silent, and I would like a lawyer if you're investigating a crime. The first 60 seconds decide everything, because if that phrase is calmly introduced early in the interaction, the dynamic changes. The stop often returns to its original purpose, addressing the traffic violation. Now here's where it gets complicated again. Invoking your rights doesn't end the stop. The officer can still request your driver's license, registration, and proof of insurance. Those are administrative requirements tied to the lawful traffic stop itself. But conversation is different. Conversation is optional, and the moment you make that clear, the officer loses one of the most powerful tools available during roadside encounters, voluntary statements. Let me tell you about a case that illustrates this perfectly. A driver was pulled over late at night for drifting slightly within their lane. The officer approached and immediately asked the usual question. "Where are you coming from?" The driver answered casually. Said they were coming from a friend's house. A few minutes later, the officer asked again while walking back from the patrol car. "So, you said you were coming from work tonight?" The driver corrected him. "No, I said a friend's house." But the officer had already written something down. During the suppression hearing, the officer testified that the driver had given inconsistent statements about their location. That inconsistency justified extending the stop and calling for a DUI unit. The judge watched the body camera footage closely, and what stood out wasn't the officer's tone. It was the driver's willingness to talk. If the driver had simply provided license and registration and declined conversation, the basis for extending the stop would have been much weaker. The first 60 seconds decide everything. Now I need to be honest about something. Invoking your rights does not guarantee a pleasant experience. This is the hard truth section nobody likes to hear. Officers are human. When someone asserts their rights early in an encounter, it can change the tone. Not always, but sometimes. The stop might feel colder. The officer may become more formal. The interaction may last longer. And some drivers interpret that as punishment. But legally, asserting your rights is not obstruction. It is not illegal. It is simply drawing a line between compliance with the law and participation in an investigation. And that line is incredibly important. Now, this is where body language matters more than people realize. The worst way to assert your rights is with attitude. Aggression invites escalation. The most effective approach is calm neutrality, hands visible, voice steady, no sarcasm, no accusations, just the phrase. I'm choosing to remain silent, and I would like a lawyer if you're investigating a crime. Then silence. The first 60 seconds decide everything. Because silence forces the interaction back into a procedural framework rather than a conversational one. And that matters. Here's where another misunderstanding appears. Many people believe that if they remain silent, officers will automatically search the vehicle or arrest them out of frustration. In reality, searches require legal justification, consent, probable cause, or specific exceptions. Without one of those, the officer's options are limited. But consent is incredibly powerful. A simple, sure, go ahead, can eliminate the need for probable cause entirely. which is why consent requests almost always come after conversation has already established a cooperative dynamic. If the first 60 seconds create that dynamic, the rest of the stop becomes easier for the officer to navigate. But if the first 60 seconds establish boundaries, the encounter tends to stay narrow. Now let's talk about adrenaline. Because when people watch body camera footage online, they often judge drivers harshly. Why did he say that? Why didn't she stay quiet? The answer is simple: fear. Being pulled over triggers a biological stress response. Heart rate increases, cognitive processing changes, memory becomes unreliable. People speak faster, louder, and less precisely. That's normal. But the legal system doesn't adjust for adrenaline. Statements made under stress are still statements, which is why rehearsing that phrase before you ever need it matters so much. I'm choosing to remain silent, and I would like a lawyer if you're investigating a crime. The first 60 seconds decide everything. Now here's the part officers rarely explain publicly. Most traffic stops begin with a decision already forming in the officer's mind. As they walk up to the car, they're evaluating dozens of subtle signals. Movement inside the vehicle, objects on the seat, smells, posture, the way someone looks at them. Those observations start shaping the encounter before a word is spoken. But conversation either confirms or disrupts that early impression. If the driver talks freely, the officer has more material to analyze. If the driver stays calm and silent, the encounter becomes more predictable. This doesn't mean every officer is looking for a reason to escalate. Many simply want to issue the citation and move on. But investigative training encourages curiosity. Curiosity leads to questions. Questions lead to answers. Answers sometimes lead to suspicion. And suspicion leads to extended stops. The first 60 seconds decide everything. Now imagine a slightly different scenario. A driver is stopped for a broken tail light. The officer approaches, asks a few questions, and the driver politely declines conversation while providing the required documents. The stop becomes procedural, license checked, registration verified, warning issued, encounter ends. But if that same driver begins explaining their night, mentioning they were at a party, admitting they had just one drink, even if they're completely sober, the stop may evolve into a DUI investigation, field sobriety tests, breath tests, extended questioning, all triggered by voluntary conversation. This is not speculation. It happens constantly. Now, this is the part most people misunderstand. Remaining silent is not about hiding guilt. It's about controlling information flow. In the legal world, information is leverage. Every statement creates possibilities for interpretation, misinterpretation, or contradiction. Silence removes those variables. But again, silence must be paired with clarity. I'm choosing to remain silent, and I would like a lawyer if you're investigating a crime. The first 60 seconds decide everything. And if there's one thing I tell clients after watching their body camera footage for the first time, it's this. The moment that changed their case almost always happened before they realized they were even in danger. A casual comment, a nervous explanation, a small admission. That's where it turns. Because once the investigative machine starts moving, it's difficult to slow it down. So if you take anything away from this conversation, let it be this simple preparation, not aggression, not hostility, preparation. Rehearse the phrase, say it out loud, get comfortable with it. Because when adrenaline hits and red lights appear in your mirror, you will not rise to the level of your expectations. You will fall to the level of your preparation. And the first 60 seconds decide everything.